Hello and welcome back to our video series on digital reform. Today we're going to look at requirements in the DSA around content moderation and specifically how illegal content gets flagged. To help provide some insights onto this topic, I'm joined by my colleague Ciara Anderson, Senior Associate in the Technology and Innovation Group.
Thanks, Aoife.
So today we're talking about the DSA and the concept of illegal content. Other videos in the series address the transparency aspects of content moderation, but today we're going to specifically zone in on illegal content and how providers are made aware of it on their platforms. Just to kick us off, could you give us a refresher on what illegal content is for the purposes of the DSA?
Absolutely. So I think the whole idea with the DSA is it's intended to make illegal online what is illegal offline. So again, illegal content is quite a bit what it says on the tin. It involves, so illegal content already includes terrorist content, for example, illegal hate speech, depending on the jurisdiction, child sex abuse material. But it is going to broaden in scope a little bit. So we're talking about information that relates to illegal activities as well. That will be deemed illegal content. So that might include information relating to counterfeit goods or the sale of goods that don't comply with consumer protection law. So the scope is a bit broader, but as we're going to discuss, the DSA does provide some pretty structured mechanisms for liability and notices that will give providers a bit of a shield as well.
Thanks, Ciara. I suppose it's just probably worth mentioning at this point that there's a related but not the same concept under the banner of harmful online content under the OSMRA, which we've discussed earlier in the series in the context of protecting children online. But today we're just going to confine ourselves to illegal content under the DSA. With that concept of illegal content in mind, could you maybe set the scene a little bit on what obligations were on providers around being made aware of illegal content on their platforms pre the DSA?
Sure. So I think most organizations had some type of content moderation program. It might be limited to very specific illegal content like terrorist content. It might be broader. Oftentimes these takedown as well encompasses breaches of their T's and C's. But it was largely self-regulated and voluntary. Organizations now will have, again, the benefit of this codified notice and takedown procedure and rules under the DSA that'll provide a bit more clarity to what were already kind of voluntary programs. And again, what we're talking about here is liability as well, when a provider can maintain their safe harbor status or when they lose that safe harbor status in relation when they become aware of illegal content.
Okay, so in terms of this shift from kind of voluntary to mandatory and what's changing under the DSA, as an initial point, it might just be worth touching on monitoring. I know there's been a lot of talk about when and how providers are made aware of illegal content on their platform, like CSAM material, and as you alluded to there, what this means for their safe harbor status.
So I mean, many organizations were conducting monitoring before. There was a public interest to do so, for example, child sex abuse material. But now the DSA helpfully codifies that monitoring will not make you lose your safe harbor status. So again, that is something that was implicit before, but is now explicit under the DSA. Okay,
that makes sense and kind of forms part of the bit of the shield that you referenced earlier on. I suppose then looking beyond monitoring, how else are providers going to be made aware of illegal content on their platform? I know you mentioned earlier notice and takedown regimes.
Yeah, so I mean the two biggest ways probably organizations are made aware of illegal content is either through their own monitoring or user notices. So the DSA has a structure, like I said, in place for what these notice and takedown and specifically user notices need to look like. But ultimately, the user notice mechanism needs to be easy to use and it needs to be accessible. So I think gone are the days where these platforms or a web form is buried behind 10 clicks. They ultimately need to be quite accessible for users.
Okay, and once the user has access to that portal, are there specific requirements on the content of the notice that they have to submit to the platform?
Yeah, and I think this is where the DSA gets very helpful for providers is there is a laundry list of information that the user needs to provide and ultimately will be set out in the provider's or organization's web form. For example, it needs to be clear on where the URL of the illegal content is, which is quite obvious, but it will also need to include a sufficiently substantiated explanation to allow that organization organization to understand that it's illegal content. So again, that is helpful for organizations to have a test of when they are made aware and when they're not, and what information these notices have to include.
Okay, again, building on that shield concept you mentioned.
Absolutely.
So beyond the user notices, are there other ways that content can get flagged to platforms?
Yeah, so we've talked about user notices, we've talked about monitoring, but another way, I mean, prior to the DSA, a lot of organizations had these bilateral arrangements with different groups that identified copyright infringing material, for example, or child sex abuse material. The DSA now, again, is codifying this previous kind of implicit practice, and it's calling them trusted flaggers. So essentially, these are experts in their field for identifying illegal content, and when an organization receives a notice from a trusted flagger, it moves quickly to take that down, and they kind of move to the top of the stack because of their knowledge and expertise in this area.
Okay, so the trusted flaggers get sent into a bit of an express lane when their notices come in.
Yeah.
I know you mentioned they have to be organizations with expertise, but are there rules around who gets selected to be a trusted flagger?
So I think it's going to be a small pool in the end. Ultimately, the trusted flagger status will be awarded by the local digital services coordinator in each jurisdiction, but they will be recognized across the EU. So if someone's recognized in France, we would recognize them as a trusted flagger here in Ireland. It's going to be groups that have particular expertise, like I mentioned. It could be Europol, or there are certain groups that have, again, a particular expertise in identifying child sex abuse material. So it'll probably be a small pool. We don't really know who they are yet because the trusted flagger provisions aren't coming into force until February of next year. So we have none yet, so it's a wait and see.
Okay, I suppose on the operational side then, once the notice comes in, what does the provider have to do?
Yeah, so I think two things happen here. So either the notice comes in and it contains all the information that the DSA requires to put the provider on notice. So again, like I said, this sufficiently substantiated explanation, as well as all those other details like the URL, etc. If that is the case, that puts the provider on notice of the illegal content. They have to move to take it down expeditiously, and if they don't, that's when they're on the hook, and that's when they're liable, and that's when they lose the safe harbor status. Going back to that test, sufficiently substantiated explanation, there's a little bit more detail there. The rule is that it needs to be enough information to put a diligent provider on notice that the content is illegal without a detailed legal examination. So again, I'm sure there'll be interpretation of this, but my reading of that is needs to be quite clear on its face without hiring an army of lawyers to try and figure out what this notice is trying to say. So that's one option. The notice contains all the information and you are on the hook. The other option is, though, that a notice comes in and it doesn't contain all the information required under the DSA. It's not clear where the content is. It's not clear why the content is illegal. And in that case, going back to the shield that we've talked about, a provider can say, no, I maintain my safe harbor status. I'm not on notice and I'm not liable for this information.
So it seems like once the provider has kind of all the information to meet that threshold, they're going to be on the hook and they're going to have to do something. Mm-hmm. But if they don't receive all that information, then they're not on the hook.
Yeah.
Okay. Are there, beyond the users and the trusted flaggers, are there any other means in which a provider can be made aware of illegal content on their platform? I'm thinking in particular of, law enforcement or court orders, that type of thing.
Yeah. So again, organizations have always received these orders from law enforcement to take down certain types of material. But as you and I know, it's been quite difficult to manage, or they're not clear, they're in a different language, you don't know what the lawful basis is, so it's been quite difficult for organizations to operationalize, I think, law enforcement takedown orders. The DSA comes in and now provides a structure for what these notices need to include. So member states will need to put rules in place for the content for these notices, which is quite helpful.
I think the providers themselves are really going to welcome this as a means by which they can defend themselves when these orders aren't clear.
Yeah. So, I mean, the information that needs to be included is quite specific. So, like I said, member states will need to set out in their local law that law enforcement orders are required to have this laundry list of information. So for example, it needs to be clear what is the basis for the order itself. What is the explanation, again, going back to the explanation of why that content is illegal under local law. So there'll have to be a reference to some type of law. It needs to be in a language that the provider understands. It needs to be sent to a specific point of contact that the provider has made known for receipt of these orders. It needs to be clear on the scope. Does it only apply in France? Does it apply across the EU? And as well, it's also going to need to contain information on redress schemes. So both for the organization who receives the order and for the affected individual whose content is taken down, is there a complaint mechanism in place? And for the organization, can they ultimately take some type of judicial appeal of the order? So yeah, I definitely think organizations will welcome that.
Absolutely. So we've covered user notices, trusted flagger notices, and kind of the law enforcement angle.
Yeah.
I suppose, is there anything else with illegal content under the DSA that providers should really be thinking about?
There's probably one final piece, and again, it's something that many organizations did on a voluntary basis and is now becoming mandatory. So most organizations would have decided to report certain information on serious criminal offenses to law enforcement of their own volition. And we've worked on this a little bit before, and organizations have probably grappled a little with the privacy concerns there, and we've done LIAs and this, that, and the other. Thankfully, that will be gone now because the DSA mandates that organizations, once they become aware of information or a reasonable suspicion that there's going to be a serious offense against the life or safety of an individual, they have to report that to law enforcement. So again, the removal of discretion is probably welcome there.
Yeah, always helpful to codify these things, particularly you're dealing with serious criminal offences.
Absolutely.
Just take down that volume of discretion.
Yep.
Well, thank you very much for sharing all your insights on illegal content today, Ciara. That's all we have time for in this video, but all of the videos in our digital reform series are available on the Arthur Cox website. Thank you very much for watching.